What's up, guys? So this is Bill Amadeo from McManus and Amadeo and Grable and Associates, and today we're doing a vlog on the Batson challenge. Our blogger also wrote an article about this. A couple quick things before we get going today. Nate Frazier and I will be doing some Facebook Lives on his podcast. We're working on a schedule for legal issues. I will be back on the radio with Nate in the near future. And I do want to send a shout out to Trishay Duckworth, our leader at Survivor Speak. Shay, I know it was your birthday. I definitely owe you dinner. Miss hanging out with you. This COVID stuff's been crazy, but looking forward to keeping up the mission of justice. We're getting there. Thanks for all you've done. You've been an amazing leader. Okay. Batson challenge is a topic that a lot of criminal defense lawyers don't know about or don't utilize. And it really has to do with voir dire. And the case it comes from is Batson versus Kentucky, which is 476 US 1979, and the case is a 1986 case. In Batson, what we can't have is jury challenges based on race, gender, ethnicity. And it's one of those situations where the Equal Protection Clause of the U.S. Constitution comes into effect in the criminal case. And let's take an example of this. Let's say, hypothetically, you are defending somebody from Ypsilanti at the 22nd Circuit Court. And your jury pool has people from Dexter, people from Ann Arbor, and people from Ypsi. One of the things that could happen is strategically a prosecutor may want to keep Ypsilanti people off of that jury. If you feel the prosecutor is trying to pull people off strictly because of race, you make a Batson challenge. Now, when you make that Batson challenge, what you're trying to argue is that the prosecutor is only trying to pull people off because of their race. If you can substantiate that, it basically becomes motion practice, and oral motions will take place right then and there. I've won 2 of these challenges in my career, and you got to remember with the Batson challenge, it's based on geography, because the way you handle a capital case in Wayne County or Macomb County or Washtenaw County or Shiawassee is extremely different. When you utilize that challenge, you need to have the pulse of the judge. If you're in a county where there's one circuit court judge and you've worked before him or her, you approach this differently as opposed if there's 65 circuit court judges. Knowing the judge and how they may react to the Batson challenge is going to be critical to how you advocate for your client. The reality is this: if we want to take someone's freedom away from them, then we want them to be tried by a jury pool of their peers. If you have a black defendant and you have 14 white jurors, and I say 14, sometimes it's 13, it ends up being 12, but you know who your alternative is and who gets pulled varies from county to county. But that's not really a fair cross section of the community. What you want is diversity. If you have diversity in your jury pool, you have a fairer shake. And even though we start with the presumption that one is innocent until being proven guilty, let's be real. Come on. That's bullshit quite a lot. You know, especially like a CSC case. There's a presumption of guilt when you walk in the door. You have to remind the jury of that you can't come in with that presumption of guilt. Sometimes the judge will be working against you. Sometimes judges will be an extension of the prosecutor. So you as a defense lawyer have to go above and beyond to protect the interest of your client. There is a presumption of innocence. Technically, as a defense lawyer, You don't have to do anything, but as a prosecutor I really respect a lot said to me before, I kind of put the offense and defense. You have to approach a case as if you're behind the eight ball when you start. You have to go on the attack. Anybody who tells you that crim law is not a street fight is somebody who either doesn't practice crim law or who shouldn't practice crim law. The Batson challenge is one way to try to even the playing field. And as some mentors of mine told me, sometimes the game changes right at jury selection. The jury will pick their sides, and here we are. The size of the community, the cross section of the community, knowing who's in that community, studying those jury questions when they're available. That's a topic for another time, but, in Wayne County, pre-COVID, you got the jury questions the day of. In Washtenaw or Shiawassee, you might get those questions 2 weeks in advance. There's a lot of things you should do when you get those questions. You need to study those questions. Know who we're talking about. Make notes before you go into voir dire. A lot of that will hinge on knowing when to make a Batson challenge and when not to make it. And just like any challenge, you need to substantiate it. If you're going to make a Batson challenge, you need to have your ducks in a row. It's a powerful tool when used properly. It can blow up in your face when used incorrectly. So, Carly, a new blogger for us, she will be publishing something soon. I'll post it. She got comments from me, a few other lawyers, and we'll get that going. But, Batson challenge, think about it. You're trying to find a fair cross section of the community, and the Batson challenge is one way it can be done. All right, guys, stay safe. Try and watch some college football. Let's get through this COVID crap. See ya.